Sharma sir to take the seat on the time, because as you know today's whole program is tight packed. That's why if we start now, it will be better. If you have seen the program written, there is souvenir, various features of the Companies Act 2013, and these two features are very much related to the area of corporate governance, as actually in late 80s in our postgraduation term corporate governance. Because what is corporate governance we did not know. That was a control. Government used to dictate the companies if they used to issue shares. It was also there was a certain person, a body called controller of some kind of formula, and that they will dictate your shares in this price only. Not these kind of things. Okay, no, the companies must be given some kind of relaxation so that they can run according to the rules. The country should prosper. Because we have learned that the communism was there, all these big countries, because of the control economy, and in 1992 we had some kind of other problems, so that compulsion we had to make open the Indian economy for liberalization, globalization, and that's why many of the things in Companies Act were relaxed. As you know, there is a diverse between ownership and management. It is not the case of a sole trader. A sole trader himself, he runs the business. And that's why the government is there to see that we wish that the money should go to capital market rather than money market. A normal person like us will go for our investment to a bank in a fixed deposits. Or either we can, some people may tell that no, the interest rate in post office may be better. But as far as our business school is concerned or any other things, we promote people, we induce people to invest in the capital market by way of investing in shares of corporates. But there is a risk. We may tell that no, you can get 8% return in a bank, while you can get 200% return, 400% return in shares. But at the same time, the reverse rule also there. You will lose entire money of your investment. And that's why when the Companies Act 2013 was promulgated, there were certain kind of regulations, but at the same time, the emphasis was given on the corporate governance. As yesterday you have seen so many discussions on corporate governance. Today's first session is a bit technical. Two of the speakers, they are here. They will be issuing of two.
Practicing in Guwahati since 2000, and fortunately my in-laws are also from Tezpur, so I had an opportunity with Tezpur, a beautiful university, beautiful campus. We had really, it's a fantastic university, fantastic campus infrastructure. We are fortunate and must feel privileged that you are part of this university. Outside of that time, Tezpur University and our Board of Studies, we started Accountants of India, and Guwahati branch we started Accountants of India, for giving me this opportunity to share my views on Companies Act 2013. Why I am saying share my views? Because the act is very new. We are still going deep into that, trying to find out what are the loopholes, what are the shortcomings, advise the government through our institute. As Sarkar has pointed out, many amendments are in pipeline. Some amendments are placed in the parliament, and in near future we may see a lot of changes in the Companies Act 2013, because the new Companies Act, the journey for new Companies Act started way back 12-15 years back. It was placed in parliament, then it could not be passed. Finally it was the light of the day in 2013, in the last year of 2. But we as an institute and the stakeholders and the companies, there are so many issues in the Companies Act. As Mr. Sarkar actually told why this Companies Act 2013 has come, because after liberalization, with the liberalization, the more power, more autonomy has been given to the board, but the public money is involved, financial institution money is involved. So ultimately there were some frauds like Satyam case and Ron case. Then everyone thought Companies Act needs to be amended, and the outcome is the new Companies Act with lot of stringent penalties, prosecution provisions are there. But unfortunately, all the companies, whether it's a private companies, public companies, listed companies, all companies are taken to same boat, same prosecution, most of the liberalization. But who is going to follow? Who is going to come to the government? be appointed by the directors only. So it is very important to know who are the directors, how they are appointed. And in this Companies Act 2013, the government has tried to make the board more accountable, more transparent, and accountable to the government, stakeholder, financial institutions. So many provisions have been inserted, how to appoint the directors, what types of directors to be there in a board, and how to run the company, what are the provisions, prosecutions, penalties on the directors. Earlier, in many cases, directors, even if they have done something, but it cannot be proved, or they are not prosecuted, or they are not penalized. But in the Companies Act 2013, it will be very difficult for a director, if he is involved, part and parcel of any fraud, he cannot escape from the prosecution and penalties. So before I move to the technicalities of appointment of board of directors basically, we need to know what the term director is. In general terminology, you must be a director of a film. We know everyone is in directing a film, we used to watch movies. So director, in general terms, we know director is a person who directs anything, to give direction to anything. Similarly, a company, you must be aware, a company is a separate, distinct entity apart from the owner, the shareholder. Maybe some of the shareholder may be the director of the company, but the ownership is different, directors are different, and the shareholders are different. So, who will run the company? There has to be someone to run the company, so directors are there. One director cannot be given the responsibility to run the entire show, because if we allow one director or one person to run the entire show, or crores of rupees involved, then we will do something wrong. So the concept of board of directors come up. So the company is run by board of directors consisting of some directors. There are rules, how many directors to be there, minimum director, maximum director. So what is director? As per Companies Act, director means a director appointed to the board of a company. As I have discussed, board runs the company and board consists of directors. That means a person who has been appointed as a director by the company, as per the provisions of the Companies Act 2013, he will be treated as a director. It's a very simple definition for director. But the consortium of directors is a bunch of directors, a team of directors who actually run the company is called board of directors. The board of directors in relation to a company means the collective body of the directors of the company. Board is the supreme authority of a company, who is the, you can say, is the brain part of the company, who runs the company, who takes the decision where to invest, how to invest, how much dividend to be given to the shareholder, who is to be the director, who is to be the auditor. But it is not that the entire authority has been given to the board of directors. Board of directors also has to follow the guidance, take approval from the general body, that is the body of the shareholders. Board of directors has been given some powers. I will not go in detail into the powers because my area is appointment of directors. But board has been given powers, but there are restrictions as well, to invest up to such extent to some company, to invest up to such extent in some related companies, not to do this, or if to do this with the prior approval of the general body, that is general meeting, that is shareholders body, or with the prior approval of the government of India. So this is the basic of what directors is and what board of director is. Now a question comes to everyone's mind: who can be a director? There is no qualification in the Companies Act 2013 who cannot be a director. Anyone can be a director, but subject to, if it does not possess this qualification. So the disqualification is disqualification is prescribed under section 164 of the Companies Act. A person shall not be eligible for appointment of a director gifted by court, and apart from this, he must be for being sentenced imprisonment for at least 6 months, not less than 6 months. This was earlier also in 1956 Act. A new provision which was added is provided further that if a person has been convicted to an offence and sentenced in respect thereof of imprisonment for a period of 7 years or more, he shall not be eligible to appoint as a director in any company. Because once a person has been convicted, imprisonment for 6 months or 7 months, then 5 years after his sentence is complete, 5 years is passed, he can be again appointed as a director. But if a person has been imprisoned for 7 years, thereafter he cannot be a director of any company forever. He is totally disqualified for whole his of life to become a director of any company. Next, he has been disqualified by order of tribunal. He has been disqualified for appointment as a director by court or tribunal, and the order is in force. A court, there is a company or tribunal is there. If they found that he is not qualified to be a director and it has been passed, a order has been passed that he cannot be a director, in that case he cannot be a director. He has not paid tax in respect of any shares of the company held by you, whether alone or jointly with others, and 6 months have elapsed from the date last fixed for the payment of costs. Suppose you apply for shares in a company, we pay share application money. Sometimes there are some issues where you have to pay part of the capital as share application money. Then there is a call, first call, second call. Suppose 10 rupees nominal value share is there. At the time of share application, you pay 5 rupees. In first call, 2 rupees you have to pay. In second call, 3 rupees you pay. Once full amount is paid, it is called fully paid up share. Or if you don't 5 rupees has been paid, you have been allotted share, it is called partly paid up share. Suppose one is pending for a director and the due date has passed, 6 months from the date has passed, thereafter he cannot be a director if any is outstanding on his personal account as a shareholder of the company. And again, a new provision has been added in 2013. He has been convicted of the offence dealing with related party transaction under section 188 every time during the last preceding 5 years. Related party transaction, related party means those parties to whom director, the person proposed to be a director is related as a relative, as a partner in a firm, as a proprietor in a firm, in a company where he is a controlling share, or he is a company where he is controlling voting right. So those parties are called related party transactions. This is a detailed and discussed in section 188. What is related party? So if he has any convicted for any offence, related party transaction. Suppose a director who is related to he is a partnership firm where he is a partner, and the company in which he is a director, he has allotted a work to him at a price much higher than a market price, and court found that because of his own interest he has done this, his intention was not good, not in the interest of the company, and court convicted him for doing this because he has siphoned off the money of the company. In that case, and the court has to convict him. The allegation will not be sufficient. If court has convicted him for this, then he will be qualified director. He has not complied with the subsection 3 of section 152 DIN number. DIN number, I will go in detail for DIN number, what is DIN number, how it is to be applied in my later part of my presentation. DIN number, the full form is director identification number. Just like PAN number, PAN card, PAN number you must, all of you must have heard, PAN number. Similarly, there is a DIN number for directors. This is a big directors identification for all companies. Just we have one PAN number. Accordingly, we have one DIN number for a person to be a director. We can manage directorship. So these, what is director? We have just discussed. What is board and who can be a director, who cannot be a director. Company passes a resolution in its general meeting that if they will have more directors, more than 15. They can have more directors, or having more directors. If suppose is a public A limited is public company, is director in A limited, is also director in B private limited, which is subsidiary of A limited. Then this B private, even if it is a private limited B, that will be also counted for 10 numbers of directors in public company. So a person can be a director in not more than 20 companies. Out of this 20 company, 10 company, not more than 10 company, public company. Public company includes not only public company, holding and subsidiary of public company. Director, in how many companies you can be a director? That I think you all have understood. Next, in the new Companies Act, what are the types of directors? There are certain types of director which comprises of a board of directors. There are some conditions, rules, certain friend. This one director has to be there in a board, one government director or resident director or independent director. Based on the type of company, private company, listed company with some capital or turnover. So, in a nutshell, mainly the directors are resident director, women director, independent director, managing director, whole-time director, additional director, and alternate director. We will discuss one by one in next slides. The resident director, this is for the first time has been inserted in Companies Act 2013. Earlier there is nothing called resident director. In a company there is not compulsory, there has to be a resident director. As for the Companies Act 2013, as per section 149(3), board of directors of every company must have at least one resident director. What is resident director? Resident director means a person who is in India at least 182 days in a previous calendar year. So in every company, there is a private, public, every company must have one director at least who is a resident director. If there is a public company, there are 3 directors. Out of these 3, one is to be a resident director, means a person who is staying in India at least for 182 days. 2% can be a full director, or a person not staying in India on regular basis, maybe 10 days, 20 days, no problem. But one director has to be resident director. Second, another new concept which has come up in 2013, women empowerment. Everywhere we are talking about and listening about women empowerment. So the Companies Act 2013 and added this provision. As per section 149(1) again, clause 1. Some type of companies, certain categories of company should have at least one woman director on the board. What are those companies? Such companies are listed company. All listed companies should have one woman director, and all public company having paid up capital of rupees 100 crore or more or turnover of 300 crores or more. Basically, the idea is public listed company, where public money is involved, they want a woman director, and public companies, even if not listed, but big companies having turnover paid up capital of 100 crores, turnover of 300 crores, there the companies at once, there should be a woman director. Next, independent director. This word was also there, not there in the Companies Act 2013. Although the compulsion of independent director was there as per the listing agreement, as per the provisions of the SEBI, Securities and Exchange Board of India, for the listed company, independent director has to be there, but there was no concept of independent director in the Companies Act 56. In Companies Act 2013, in the Act itself, provision for having independent director has been inserted in. As per section 149(4), it says at least 1/3 of the total number of directors of every public listed company has to be independent director. The word used here is every public listed companies. 1/3 of every public listed companies. Suppose as we discussed earlier, minimum 3 directors. If you are in a public listed company, there are 3 directors. 1/3 means one director has to be independent director. If they go up to the maximum limit 15, 1/3 means 5 directors has to be independent director. We will discuss in later part what is independent director. Further, this is in the Act. Again, there are some rules has been prescribed. In this Companies Act 2013, apart from Act, there are so many rules. Rule 1, 2, 3, there are 13, 15 rules and notification has been given, on the basis of which the company law has to be complied with. As the Rule 4 of the Companies Appointment and Qualification of Directors Rule 2014. The following class of companies have at least 2 directors as independent director. The earlier provision has been inserted in Companies Act. This is only for public listed company. The second provision is for following class of company have at least 2 independent directors. What are those companies? The public company having paid up share capital of 10 crore rupees or more. Any public company, even if it is not listed, but they are having a minimum paid up capital of rupees 10 crore or more, need to have at least 2 independent directors. They are required to follow the first provision because that is applicable only in case of public listed company. But a company which is not public listed company, but having a paid up capital of 10 crore or more, need to have at least 2 independent directors. The other condition is the public company having turnover of 100 crore rupees or more, mind the word written is or any of the condition if is fulfilled, then they need to have two independent directors. It is not that both the conditions to be fulfilled. If they are having a paid-up capital of 10 crore or more, then also they need to have two independent directors. Even if their paid-up capital is less than 10 crore, but their turnover is more than 100 crore, then also they need to have two independent directors. Or a public company which have in aggregate outstanding loan, debenture and deposits exceeding 50 crore rupees. By way of maybe not by way of public issue, but maybe private placement invested. So to safeguard the interest of the stakeholders, the concept of independent company, even in case not a listed company, but these three conditions is fulfilled, they need to have at least two independent directors. Now, what is independent director? Who is an independent director? As per 149(6) means a director other than a managing director or whole-time director. Managing director will discuss later. Managing director is a person who has been given the maximum power to take decision by the board, ratified by the general meeting, and appointed as a managing director. A person who is not a managing director. A whole-time director means a director who is in full-time employment of the company. He cannot also be an independent director. A director other than a managing director or a whole-time director or a nominee director. These three what we will discuss later. Provided he is a person of integrity and possesses relevant expertise and experience. B, who is not a promoter of a company or its holding subsidiary associate company. Who is not related to promoter or director in the company, its holding subsidiary associates. To 2% or more of the gross turnover or total income of rupees 50 lakh, whichever is lower during the two immediately preceding financial year or during the current financial year. Who neither himself nor any of his relatives is an employee or proprietor or a partner in any of the three financial years, immediately the financial year in which he is supposed to be appointed of a firm of auditor or company secretary in practice, post auditor or company, subsidiary or associate company, a legal firm in which he is having 10% or more firm, holds together with his relative 2% or more of the total voting power of that company in which he is proposed to be the director, or is the chief executive or director of any non-profit organization that receive 25% or more of the receipt from the company, or hold 2% or more of voting power of the company. So in a nutshell, when we go through this 149(6), we will notice that the word independent itself, you can understand what mean by independent director. Independent director has to be independent of the company. He should not have any relation. But sometimes, why they have given the exhaustive list, because he might not have a direct relationship with the company, his relative, his wife, his sons might be holding some shares, might be holding some portfolio in the company, might be holding some managerial position. In that case, there will be no independence. Because if my relative is in a company, I might take some decision which is beneficial to that person. So the basic concept to have an independent director who don't have any relation with the company, financial or otherwise, no relation with the company, not any relation with the relative of the company of his who is appointed or anywhere related with the company, any relation with a firm where he is which is working for that company. Suppose I am a chartered accountant, my firm is auditing for a company, my partner cannot be independent director in that company. If I am a legal firm giving legal services to that company, but my partner or my wife cannot be independent director in that company. Because if he becomes or she becomes independent director of the company, when the proposal for giving remuneration to my firm will come, you will definitely vote for the next remuneration. So there will not be any independence. So the basic idea, to have a director who is independent of the company, who can ring the bell if there is, you can blow the whistle if there is something goes wrong. So the concept of this independent directors come, and every company, as I have discussed earlier, every listed company should have at least 1/3 number as independent director. To paying something, and again, the remuneration which can be paid to an independent director is not entitled for a stock option. You must be knowing stock option is an option given to an employee of the company to buy a share at a specific price after a specific date. Suppose today you are an employee of a company, you are in some position as a company policy, you have been given 2,000 shares of the company at a price of 40 to opt for this option 3 years later. 3 3 years down the line, the share price has gone up to 200, you will definitely exercise that option, you will buy the share. So that, but that option is not available to independent director. He may receive remuneration by way of fees, reimbursement of expenses for participation in the board, in other meeting, and profit-related commission as approved by the board. Because of his expertise, if the company is earning profit, he is eligible for getting some commission on account of that profit. Again, another restriction has been given even for the independent director, that an independent director shall hold office for a period of 5 years consecutively on the board of a company and eligible for reappointment on passing of a special resolution by the company. An independent director can be a director in the company only for a consecutive period of 5 years. He is eligible for reappointment subject to passing a special resolution. There is a difference between ordinary resolution and special resolution. If you go deep into the meetings and proceedings, you will come to know. So only after passing a special resolution, he can be reappointed for the next term. But again, no ID shall hold office for more than 2 consecutive terms. That means one person cannot be independent director in a company for more than 10 years. Why so? Because if you are a director in a company, even if at the time of appointment you are independent, but working with some company or some organization for 10 long years, definitely you will have some relationship, have some personal interest, you have a good relationship with the directors, then your independence will lose. So the company has provided that you cannot be continuously director for more than 10 years in a company. Provided further that he shall be eligible for reappointment after the expiry of 3 years of ceasing to be an independent director. 10 years completed, 3 years he cannot be a director. After 3 years again he can be appointed as independent director. Further, such an ID shall not be appointed to associate with any company, any capacity, either directly or indirectly in those 3 years. After the completion of 10 years, suppose I am an independent director, or independent director in AB Limited, and after completing 10 years, we have got good relationship with all the company directors, AB Limited, their subsidiaries, their holding, their associate companies, and you cannot become the not even director in any other company, not that company, not associated company, not related company, holding subsidiary, because otherwise you are not again eligible for becoming an independent director. After sitting 10 years, you can be a director in any company, not as an independent director. And if you are a director in any company, after 3 years also you cannot be appointed as an independent director. Managerial person. This new word has been also coined in this Companies Act 2013. As per section 203 of the Companies Act, read with Rule 8 of the Company's Appointment and Remuneration of Managerial Person Rule 2014. See, for director appointment remuneration, there are, apart from Companies Act 2013, there are 2 other rules. One I discussed earlier, and this is the second rule which you have to take into consideration while you want to have idea about in detail about these things. Because there are some conditions, I don't know why they have done in the Companies Act, they have given some conditions. Suppose for a director, he cannot, for other companies, there is a minimum 2 directors. It is given in the rule again. So if you read the act only, then you will lose that idea. You may be wrong somewhere. So you have to read law, this rule along with the act. Both this rule along with that together, then only you will get big idea what the actually act is. Every listed company, every public company having a better capital of 10 crore or more shall have full-time key managerial person comprising of managing director, I told you in the type of director what is CEO or manager, and in their absence full-time director, company secretary or chief financial officer. So all listed company should have at least this 4 person as the key managerial person who will be responsible for everything, and KMP is Devajit will tell you in detail during his projection and penalty provision. KMP is solely responsible and they are liable for everything, every wrong done, they are officer in default. So these are very key person for the management of the company. They take all the decisions, they are responsible as well, and they will be penalized as well for anything goes wrong because of their negligence or their. So the word here are managing director will discuss, rest whole time that will discuss, company secretary, chief financial officer we are going to discuss here. Managing director. What is managing director? Managing director means a director who by virtue of this article of the company or an agreement with the company or in a resolution passed by its general meeting or its board is entrusted with the substantial power of management of the affairs of the company and includes a director occupying the position of MD by whatever name called. The word managing director itself says is a director but a person who is managing the show. he has been given maximum power to do things. But appointment of director is generally done by through article of association at the time of formation of company, or by the board, or by the general meeting. There is an agreement, there is an appointment letter, and all the powers has been listed. But sometimes you may find in a company there is no appointment has been done, but a person, a director, who is looking after all the work a managing director is supposed to do, then he will be also be treated as a managing director. Even if he is not appointed as a managing director, but he has been interested with those powers, he is doing what a managing director is supposed to do, so directly he will be treated as a managing director. Whole-time director includes a director who is the whole-time employment of the company, means a general director, but because terms of appointment, he is in the full-time employment of the company. Additional director, the board may, if authorized by articles, appoint any person other than who failed to get appointed as a director in general meeting as an additional director. That we will discuss later how the appointment takes place and why this requirement of additional director comes up. Alternate director means a director, if authorized by article of association, is appointed by a board or by a general meeting as an alternate director during the absence of a director for a continuous period of not less than 3 months from the country. So this is all about what the director is, what are the types of director, what is the formation of board, how the group of board directors manage the soul of the company. Now the basic, the main subject, that is how to appoint the directors. Appointment of director, we will discuss how the director's appointment takes place as per the provision of the Companies Act. First director. Where no provision has been made in the article for appointment of first director, the subscriber of the memorandum association who are individuals shall be deemed to the first director until the director duly appointed. When a company is formed, the basic document of formation of a company is memorandum of association and article of association. Article of association is basically the bylaws, how the company will be running, what is the powers of directors, all those things will be there. And the memorandum of association is the object clause, capital clause, capital clause, all those things are there. What is the prime object of the association? Suppose in the article of association nothing is been prescribed who will be the first director. Because when a company is formed, on the register of company form a company, give a certificate of incorporation, immediately someone has to be there to run a company. That mostly in the article of association, the name of the first director is specifically mentioned. It is 3% will be the first director of the company. There might be a situation where there is nothing has been prescribed who will be the first director. In that case, those who are the subscriber of the memorandum or article of association, subscriber means the promoters, or you can say those people who subscribe to the shares of the company for the purpose of formation, those will be treated as the first director of the company. They will be the first director of the company. Apart from the first director, now this is 152.1, second is 152.2. Section as per 152.2, all directors now will be appointed in general meeting only. Director, other than first directors, all directors will be appointed by general meeting, because board has not been given the power to appoint the directors now. These are the basic provisions of 152. No person can be appointed a director unless he has been allotted a DIN, that is director identification number. Every director who is to be has been appointed as a director is to give in writing that he is not disqualified to become a director as per the provision of 164, which we have discussed earlier. Because a company who wants to appoint you as a director, he might not be knowing what are the disqualifications. You have to give a certificate that I am not having any disqualification as prescribed in 164. Because if he is related somewhere or he has been convicted by court in some other places, company might not be knowing. So you have to give a declaration. On the basis of that declaration, the company can accept he is not disqualified. A person appointed as a director shall not act as such unless he gives his consent in writing, and such consent is filed with the registrar of companies within 30 days with the registrar of companies. Earlier, as soon as the director is appointed, he become a director, he can work. Later on, after 2 years, 3 years, I don't know, I have been appointed as a director, I have not given any consent, all those things happen. Now, if you have been appointed as a director, apart from giving that I am not disqualified, giving your DIN number, you have to give in writing that I give my consent to act as a director of such and such company, and that information should also go to the registrar of company, so that in future you cannot deny or escape from any responsibility. You Mr. A, B, C, D, and so has been appointed as a director, or a resolution has been, proposal has been moved to the general meeting. We want to appoint Mr. A, B, C, D, E, F. Now the Company Act says no, you cannot move such a resolution. You have to move yes, Mr. A is proposed to be a director, pass a resolution. Mr. B proposed to be a director. You have to have separate resolution for everything. However, if the company in general meeting pass a resolution, yes, we can appoint director in single resolution, all the directors. In that case, then they can appoint director in a single resolution. So these are the basic, very basic of the appointment of directors. What are the things we observe? DIN number. We have seen earlier in disqualification also, if he can be disqualified if he is disqualified number, he has not followed 152.3, if you don't have a DIN. In the appointment of directors, also we have discussed that if you don't have a DIN, you cannot be appointed as a director. So DIN becomes very important. To become a director, first you need to have a DIN. DIN is director identification number. As I told you, just like PAN number, this is called DIN number, that is director identification number. As per the provision 152.3, no person can be appointed as a director unless he has been allocated DIN number. For the allotment of DIN, following procedure need to be followed. Then again, the rule for application of DIN number and getting the DIN number is again in the Appointment and Qualification of Directors Rule 2014, which says if you want to be a director in a company, first what you need to do is apply for a DIN, that is director identification number. How to apply DIN? DIN, for application of DIN, you have to go to the MCA site, Ministry of Company Affairs. There is in the left side there is a link, application for DIN number. You click there, online form DR3 will come. In application form, DR3 has to be filled to the central government along with the following attachment. What you need to submit to apply for a DIN? Photograph, ID, your identity card, identity proof, your residence proof, verification of application in DR4. Director fee to be verified by CA, CSR. When you apply for a DIN, whatever information you are putting, you are giving by web scan, putting your own signature. Whether you are giving the information true or not, for that a verification is to be done by a company secretary or a chartered accountant or a ICAA. In practice, not in on submission of that application, a provisional DIN will automatically come. Immediately a provisional DIN will be given to you, but you cannot use the provisional DIN unless the confirmed DIN has been given to you. Generally, DIN has been immediately allotted if you are applying online with the help of digital signature. But if you are applying offline and you are submitting offline reports, then it may take 2 days for allotment of DIN. But unless your final DIN has been allotted, even if you are having the DIN number, the provisional DIN number will continue to be a final DIN number, but you cannot use that DIN number as your DIN number for the purpose of appointment of a company. And that is just like if you have a pen, it's not necessary that you have to file your return. You are having a pen, that doesn't mean you have a taxable income. Similarly, if you are having a DIN, that doesn't mean you are a director. But for the appointment of a director, you need a DIN. Today you can also have a DIN number. You can just go through the site and apply for a DIN and have a DIN number. There is no formalities to be followed in future. If you have applied for DIN number, you have to file return and so this. But whenever you want to be a director in a company, you need a DIN. So you can have a DIN today also. Any one of you can have a DIN. You can surrender the DIN as well by submitting DIN 5, form DIN 5, giving the reason for surrender, why you are surrendering. You may say that I don't want to be a director in any company, or whatever reason, the DIN can be surrendered. Changes in DIN in the particular submitted at the time of DR3. When you apply for the DIN number, you have given ID proof, residence proof. Photograph, there is no question of any change in the photograph, but ID proof of residence proof, there may be changes in your residence proof. In that case, you have to intimate. There may be some mistake also. Recently, you must have heard there was some, by mistake, Priyanka Gandhi has been allotted 2 DIN numbers. So there was so much of hue and cry that he wanted to do the fraud and cheating and all those things. He said this was mistakenly issued to Priyanka Gandhi. So if there is any such issue that 2 DIN number has been allotted or there is some mistake in the DIN, you should immediately apply within 30 days in DR6 form. So these are the mistakes, so these are the changes I want to make in DIN number. Otherwise there are penal consequences which I am not going to discuss. Be a director. Number 3, what the director is supposed to do. Number 3, give a declaration that I am not disqualified to become a director of the company. These 3 things are must to for appointment of a director. then the company has to follow the rules, these things, passing the resolution or putting the application in with the ROC that we have appointed. So these are the basic rules. The consent in DI2 has to be obtained from the person to be appointed as director and to be filed with the ROC within 30 days along with DIN. Then again we have seen DIR and DIN 2 both are compulsory. To obtain from DIR 8 with regard to no disqualification, as I told you, these three things are must: DIN number, consent, and no disqualification. No disqualification is given in DIR 8, and director to be appointed in general meeting by individual resolution. As I told, you cannot have single resolution for more than one directors unless you pass in general meeting. So you have to pass a resolution in the general meeting that so and so person, Mr. A, Mr. X is appointed as a director. After taking all these things, then DI 12, this is the information to be provided to the registrar of company that we have appointed so and so person as the director of the company. There is a general procedure for appointment of any type of director, whether alternate director, additional director, all type of director. This formality has to be followed in case of appointment of all type of directors. Now, as I told you, there are all 2/3 of directors of every company has to be director retiring by rotation. So, the procedure for reappointment of retiring directors. Retiring director out of 15, 10 directors is liable to retire by rotation. You want to reappoint him. What to do? Board meeting is to be convened after giving notice to all the directors. You have to give notice to all the 15 directors. These 10 directors are going to be retired, but we want to reappoint this such person or all the 10% as a director. Fix up a date, place, time and place for general AGM. Because all directors retire by rotation only in AGM only. At the time in the AGM you fix up the date, pass a resolution and upload DI 12 along with DI 2, DI 8, and he can be reappointed as a director. So that's why I have written in the last line, in addition to the above, all general procedure. That's why I have discussed the general procedure earlier. Those is to be followed in case of all directors. Next, procedure for appointment of a person other than a retiring director. Now suppose company has 15 directors, 10 directors are going to be retired. Board may want to appoint all the 10 directors, reappoint all the 10 directors. But you being a shareholder, or you think that I can get the majority in the general meeting that I want to be a director, you can apply for become a director of the company. But person who intends to become a director or a proposer, I can propose your name. I want to appoint you as a director. In that case, 14 days prior to the company declaring a candidature of director with a deposit of 1 lakh rupees. Before AGM, 14 days before the AGM, he has to give a notice to the company that I want to propose or I want to be appointed as a director, and he has to deposit 1 lakh rupees to the company. He has followed, then a resolution if it is passed, DI 12 has to file, and the other person other than the retiring director can be appointed as a director. Next, procedure for appointment of an independent director. For independent director, we have discussed the qualification, what quality he has to possess. Board will propose the name and in the AGM notice an explanatory statement stating that all the conditions specified in Act and rule are followed. Because for appointment of all the directors, I told you it will be in a general meeting only. Board will propose a name. Board will find out a person who is capable of being appointed as independent director. In the notice for AGM, they will give explanatory statement why they want to appoint, what are the qualities, what are the tenure, everything they have to give. Explanatory statement is a statement which is attached with a notice in case of special legislation to be passed. So they give this explanatory statement that these are the qualities of a person, why they want to appoint, everything they will give. And check whether all condition of 152, as we discussed earlier, DIN, consent, everything. If the resolution is approved by the general meeting for appointment of that person as independent director, he will be appointed by filing DI 12 and an appointment letter will be issued. Because he is not a person appointed as independent director, appointment letter is to be issued with this consent condition. Additional director, we have discussed earlier what is additional director. The board can appoint a person as additional director. So additional director can be appointed only if it is authorized by the article of the company. If there is no provision in the article of association for appointment of additional director cannot be appointed. The total number of directors including additional director cannot exceed the maximum number. Suppose the company is having 14 directors and the company is not passed to have more than 15 directors and they want to appoint 2 additional directors, they cannot appoint. They can appoint only 1 additional director. Meeting of the board has to be conveyed, a resolution for appointment has to be passed in the board meeting, all other general provision has to be followed. But the additional director is generally appointed in between one AGM to another AGM. Because if there is an AGM, general meeting, then a person other than retiring director can be appointed. So additional director is appointed in between two AGM. The board has the power to appoint one or more or two additional directors subject to maximum CA. If they appointed additional director, he can be additional director only up to the period of next AGM. In the next AGM, he will definitely retire unless he has been reappointed as a regular director. Otherwise, he has to retire. His period is only up to the next AGM. Who is outside the state or outside the country for minimum 3 months. Total number of directors again cannot exceed maximum. A meeting of the board can appoint. This power is given to board. A meeting of the board has to be convened. A resolution is passed in the board meeting. All other general provision, DIR 12, DIR 8, DIR 3, DIN numbers, consent, everything is to be followed. The alternate director who has been appointed in place of a director, suppose you are a director, you are going to be in place for 3-4 months. I have been appointed in your place, or you have been appointed in this place as a director, and you can be a director, cease to be a director, you will automatically become director because you are appointed in this place. What is casual vacancy? A died or resigned. Company is having 8 directors, therefore they cannot run the company. So with 8 directors, they want to appoint 2 more directors in place of the people who is resigned or insolvent or become disqualified because of the provision 164. In that case, also board has authority. Convey a board meeting. The board meeting for appointment of casual vacancy, all other provisions which I have discussed first, the general provision this will be followed, consent and request confirmation. I am a director for a period of 2 more years only. So the person who will be appointed in my place, he cannot hold office for more than 2 years. He can be a director only for 2 years. He cannot be director for longer period. If you want to be director for longer period, he has to follow the other route of reappointment. There is another new director procedure for appointment of small shareholder directors. Small shareholder director in case of public listed company, you might find that there are small shareholders, 70,000, 1 lakh, 2 lakh shareholders in a company. So there is a provision in that. This is applicable to shareholders who are having shares of nominal value of 20,000, not the market value. Nominal value is the face value. Suppose share of 10 rupees. Now maybe then the stock exchange the price is 10,000 rupees. Then 2 share holding 20,000 will not be sufficient. He has to hold 2,000 share of 10 rupees. Whatever is the market price. Nominal value of 20,000 he is called small shareholder. A listed company may appoint 14 days prior to the notice of not less than 1,000 shareholders. The 1,000 shareholder of Reliance Industries, suppose we take an example of Reliance Industries, 1,000 shareholder of Reliance, small shareholders we already discussed, 1,000 small shareholders of Reliance Industries give a notice to the company that they want to appoint a representative shareholder on their behalf, small shareholders behalf. Then they have to apply, give a notice to the company 14 days prior to that with their list who are the applicant, the person whom they want to propose as a director. If he is also holding some shares, he has to give the share number, his folio numbers, everything. And period of 3 consecutive years without reappointment. Just like independent director, I told you 5 years, again 5 years, no more. Here only 3 years unless reappointed. And a small shareholder director cannot be a director in more than 2 companies. Suppose I have been approached or proposed to be a director in Reliance Industries by small shareholders, and again in another company, then in third company I cannot be proposed as a small shareholder director. Nominee directors are those directors which are appointed by financial institution or government. Suppose a bank has given 10,000 crore rupees as an unsecured loan or CC whatever to a company. In that case, the bank wants that their interest is safeguarded. So they have the power to appoint a nominee director who will look after how the company is running, whether the money is properly used for the purpose for which they revenue. So they can again the nominee director, there are some conditions. He will not be treated as an independent director, although he is independent to the company, but he will not be treated as an independent director. The procedure is same as of additional director, not liable to retire by rotation. He will remain part of 1/3, cannot be removed by the company. Nominee director cannot be removed by the company. So these are in nutshell all the types of directors who are to be appointed. What are the procedure? The procedure you have to follow, and specific procedure, post-mortem procedure director, additional director, alternate director, all those things are there. Now when the director is removed, appointed, then he should be given the option to resign. And any director can resign by giving a notice with the reason why I want to resign. Company has to file DI2 within 30 days of receipt of resignation with the reason. Just for appointment DI2 has to file, resignation also DI2 will file. We have intimated that such a person has been appointed as director. If you want to resign, you have to intimate to the ROC that such person don't want to be director. The resigning director shall also forward a copy of his resignation to the ROC. Here this additional condition being given. Earlier only if I want to resign from a company, I give a resignation letter to the company. Company will file, earlier there was form 32, now DI12. Company will file that he has resigned. Now extra liability has been considered on the director want to resign, he is also to file in the year 11 that I am resigning for the number. Because otherwise what has happened earlier, the person has given a resignation letter, the company not filed information to the ROC. Then something wrong goes, the director saying, no, I have already resigned, ROC says, I don't know, you have not resigned. So to overcome these difficulties, now the person who wants to resign, he will also need to file information to the ROC. Next, 2 slides only. 5 minutes I have? 2-3 minutes. Removal of director. A director has resigned. He has the option to resign. Company also need to have an option if he want to remove a director. A director other than director appointed by tribunal. Under section 2, government, a tribunal is appointed. You need to understand what remuneration you can get. To have an interest to being appointed as a director. There is no restriction on remuneration of private company. In the Companies Act 2030, there is no restriction. For a public company, maximum remuneration to all the directors, that is all the board, is 11% of the net profit. Computed as per section 198. There is a system of calculation of net profit, not profit as per paid account. There are some other adjustment need to be done. Whatever profit comes, maximum remuneration given to all the directors together is not more than 11% of the company. So we have discussed 11% of net profit, 10% net profit. Now what will happen if there is no profit in the company? A person director is working, you have to pay him. So there is another provision as per Schedule 5. In case of inadequate profit, remuneration can be payable with the approval of the general meeting. In case of inadequate profit, approval of general meeting is a must. In that case, effective capital, there is a criteria, if negative or 5 crore. If your net worth of the company is either negative or net worth is 5 crore, maximum remuneration allowed is 30 lakh yearly. But the penalty and prosecution, Devajit will take you to those slides. What are the penalty and prosecution, the horror part of Companies Act. We are also afraid of that part because on chartered accountants also there are huge penalties, provisions are there, punishments are there, prosecutions are there in case of wrong done by chartered accountant even. With this, thank you very much for patient hearing. Thank you.
I think we have noted certain questions for you afterwards to discuss. And very nice to listen to you. And it's a whole chapter on appointment of directors. We have covered it in 50 minutes, which I think students have already benefited all these things. I think you have some questions on this. And when the penalties and prosecutions are also deliberated, after that we'll sit together there. You can put the questions addressed to us. Alright? So I request Devajit Sharma to just go for that particular provisions of Companies Act on penalties and prosecutions.
If he is aware that there is a contravention that has taken place, how is he aware? He can be aware through minutes which are circulated for him. And silence is not golden. If he does not resist or does not abstain in a meeting where a contravention is being discussed or some contravention is going to take place, he is also responsible as an officer in default. So any of you are aspiring to become directors in the near future, take care. So let me introduce you to the concept of penalties with a few light ones, just to prepare you for what is going to follow. I won't get too technical, I will not go too deep into the sections, but just skim the major penalties, what I see are the major penalties, but let's start with the light ones. How many of you are aware how to start a company? What is the first thing you do when you start a company? To start a company. Anybody? Before that? You've got to apply for a name. You've got to apply to reserve a name. Once the registrar has reserved that name for you and he finds out that there's incorrect information that has been provided in the form for application, you are in trouble. He can fine you under section 4, it's 452, and the fine can range from 0 to 1 lakh. So be careful while you are applying for a name. Otherwise have deep pockets. This is light one. I'll discuss a few light ones and then go on to detail, which like something that Bikash had talked about. We are really scared, he's absolutely right. I'll take that later on. Failure to intimate registered office and display name and registered office of the company. Within 15 days of registration, the registered office of the company has to be intimated and you have to display the registered office of the company. If this is not done, under section 12(8), the company and every officer in default are fined 1,000 a day for every day the default continues. And thank God there's a limit of 1 lakh rupees. If you fail to refund allotment money within prescribed time, if minimum subscription is not received, then 1,000 per day subject to maximum of 1 lakh. You have to pay the money, and the money has to be, if it's not, refundable, if it is refundable, you don't not refunded in time, you pay this fine. This is under section 39(5). Return of allotment not paid in time, made in time, subject to restrictions of section 403, additional 270 days. We won't get too technical on that. Section 42(10). Default in provisions relating to, say, private placement of shares, keeping of share money in separate accounts, etc. Now this is heavy. Share money, amount involved in the offer is a penalty, subject to a maximum of 2 crores. I don't know what small companies are going to do. Why do people want money in small companies? They want money because they don't have money. And if they make a default to here, not only do they have to refund the money, they have also got to pay a penalty equivalent to the amount sought. To understand that within the time frame that has been prescribed, it would not be possible for all the penalties and prosecutions. And I hope when I was preparing this paper, I was thinking to myself, am I encouraging students or am I discouraging students to look towards the future? Don't get discouraged. This is all, you've got to take it in a stride. Treat it as, something that is surmountable. Let's get to auditors before we get into other things. As Bikash said, we are very, very annoyed and very apprehensive. A lot of us are thinking what to do about this audit. We can't do anything. We have to wait for the government's decision if the provisions are going to be amended, which I don't think they are going to be. Section 147. If an auditor has contravened any of his duties, under section 147, well, let's skip the section, he shall pay a fine which shall not be less than 25,000 and shall not exceed 5 lakhs. तो fee होता नहीं. If convicted, he has to refund this fee. Then not a big deal. Fee तो बहुत होता है. Okay, he has to refund this fee. If an auditor, having detected fraud, does not meet the provisions of the Act for reporting such fraud, his penalty can range from 1 lakh to 25 lakhs. A resigning auditor has also not been spared. The auditor is supposed to file within 30 days of resignation documents in the prescribed form to the company and to the ROC, and sometimes in specific companies to the CAG. If that form is also not filed, the resigning auditor is liable for a fine which may extend from rupees 50,000 to rupees 5 lakhs. We'll talk about auditors once later. Let's get on to some other stuff. It's called fraud. Explanation to section 447 defines fraud. What is fraud? I think I have to read out. Any act or omission or concealment of fact or abuse of position with an intent to deceive or to gain undue advantage from or to injure the interests of the company, the shareholders, the creditors, or any other person by any person or any other person with the conveyance of in any manner, whether or not any wrongful gain or any wrongful loss is incurred or suffered. Fraud. So you don't have to, wrongful loss or wrongful gain need not be incurred. The intention is enough. That's fraud. And what is the punishment for fraud? It's any person found guilty of fraud has to pay a fine from the amount of fraud, ranging from the amount of fraud to 3 times the amount of fraud, and can face imprisonment ranging from 6 months to 10 years. And when there is public interest and public money involved, this imprisonment range cannot is from 3 years to 10 years. It cannot be less than 3 years. So that is the penalty for fraud. Auditors convinced in fraud will come to a bit later. Section 448. Penalty for a false statement. This is highly relevant for people like us and company secretaries and cost auditors who certify a lot. Penalty for a false statement. It corresponds to section 628 of the Companies Act of 56. A false statement in any certificate, financial statement, prospectus, or any other document required under the Act by any person which is false in material particulars, knowing fully that it is false, or by omission of any material fact knowing it is material. Any person found guilty is also liable under section 447, the fraud section, which we have discussed earlier. Section 449 is for false evidence. Any person intentionally giving false evidence in an examination on oath or solemn affirmation authorized under the Act, or in any affidavit, deposition or solemn affirmation in any matter arising out of the Act, his fine may range from 0 to rupees 10 lakhs and his imprisonment is 3 to 7 years. So imprisonment is sure. Now all of this is, I'll discuss it later. You're going to be given an opportunity to be heard. It's not that the penalty, the moment it happens, the penalty is to be paid. There is a system for adjudication which I'll discuss later on. And to top it all, section 450, when no specific penalty has been prescribed under the Act for contravention, the company and any other officer in default will have to pay a fine up to 10,000, and for repeat defaults, 1,000 rupees per day for each day the default continues. This is relatively minor, but they've given a cover here when no prescribed penalty has been given for any provision, contravention of any provision of the Act. There is a small fine which comes here. Repeated defaults, a serial offender. In case of repeated defaults, the penalty, the fine is twice that which has been prescribed by the section. Wrongful withholding of property by an officer or an employee. If any officer or employee wrongfully obtains possession of any property of the company, including cash, and having such property wrongfully withholds such property or puts it into use not authorized by the articles or the Act, there is a fine, 1 lakh to 5 lakhs. And if the refund is not delivered within the time fixed by court, then there is an imprisonment term which can last up to 2 years. And in this connection, a complaint may be filed by the company or any shareholder or any creditor. So these are the sections which deal with fraud and false statements. I had told you all earlier that we deal with fraud by auditors later. Here it is. During the audit of a company, if it is proven that the firm or its partners have acted in a fraudulent manner or aided or colluded in fraud committed by the company, its directors or officers, the liability, whether civil or criminal, in respect of any law for the time being in force, shall be of the firm and its partners jointly and severally, and the punishment shall be meted out to the partners. The punishment of imprisonment is of course not less than 6 months to 10 years, and wherefore the auditor is 3 times the amount involved in the fraud, which is again like the punishment which is meted out under section 447. There are a few other fines and penalties which, while preparing this I said there's no way I can do without writing this down, because so again, as I said, I thought I'd list out a few to discuss with you today. Section 53. If issue of shares at a discount other than in the manner specified under section 54. Who are the liable parties? The company has to pay off 6 months. Section 71(11). Failure to implement an order by a penalty on the company. Every officer in default has to pay a fine of 2 lakhs to 5 lakhs and may face a prison sentence of up to 3 years or both. Again, section 86, failure to comply with chapter 6 relating to registration of charges. All of you are familiar that all charges have to be registered. Failure to register such charges also brings upon the company as well as the officers in default substantial fines. The fine for both the company and the officers is 50,000 to 5 lakhs, but the officer in default might also face a jail term of 6 months and also have to pay the fine. Section 118(12). I'm not expecting you all to remember the sections, I'm doing it for myself. Tampering with minutes of general meeting. They've missed nothing. Any person tampering with the minutes of general meetings has to pay a fine which ranges from 25,000 to 1 lakh and might also be imprisoned for 2 years or more. Section 128(6). Default in provisions relating to the maintenance of books of accounts. Here only the officer in default is responsible to pay a fine of 50,000 to 5 lakhs and also serve a term in prison up to 1 year, maybe both. Section 129(7). Contravention of provisions for financial statements financial statements not exhibiting a true and fair view, accounting standards not being followed, etc. The officers in default here are also subject to a similar sort of fine, 50,000 to 5 lakhs and imprisonment up to a year. Is incredible. For a company, the penalty is rupees 5 lakhs to rupees 25 lakhs for contravention of this rule and section. And for the person to whom or to whose relation the loan or guarantee is given is also fined from 5 lakhs to 25 lakhs. And this person might also face a jail term of up to 6 months. Section 188(5). Contravention of the provisions of Section 188 relating to related party transactions, contracts, etc. The punishment is on the officers in default. For a listed company, the punishment is 25,000 to 5 lakhs for the officers in default and also a jail term up to a year or both. And for unlisted companies, the officers in default would have to pay a fine of ranging from 25,000 to 5 lakhs. I think this is getting a bit monotonous. It is. There are more penalties. I don't think we need to go discuss any more. I just want to share before you the fact that this Act of 30 is still not really clear to him or me. It's a very young act. Precedents have yet to be set. What is going to change, as Bikash said, what is going to change and what is not going to change? Some alterations are lying before Parliament. We hope that these issues, which are so stringent, can be diluted, toned down. But we don't really know, because once an act is passed in Parliament, there's a lethargy of parliamentarians to admit that they had got it wrong earlier. Yes, it was passed in the time of the UPL government, but it's very difficult to get changes passed under Section 462 of the Companies Act of 13, because they have to be passed in both houses of Parliament. Then only can any amendments be passed. In the beginning I had told you not to worry. There is a methodology for determining punishments. It's not that the day IRC accuses you of contravening the provisions of the Act, you're going to have to pay the fees. The central government has been given the power under Section 454 to appoint adjudicating officers. Now, it also will specify the jurisdiction of such adjudicating officers, and the officer shall not be below the rank of registrar. Now what happens is, when the contravention comes to the knowledge of the registrar will show cause the company concerned, and the company will have, or the officer will have a right to be heard. Then the registrar will decide whether the person or the company is guilty or not, and impose it. Now that's not the final verdict either. An appeal lies to the regional director of the company law board. The regional director will adjudicate on, if an appeal is passed, appeal is preferred, the regional director will adjudicate, and then, hearing both sides of the story, the registrars as well as the appellants, will adjudicate. Okay? This appeal to the regional director has to be filed within 60 days of the verdict by the registrar of companies. Then the regional director adjudicates, and then the fine becomes final. After that, there is a last penalty. There is a penalty on a penalty. If this penalty is not paid by those responsible for paying the penalty in 90 days, then a company might have to pay a further fine ranging from 25,000 to 5 lakhs. The officer in default might have to pay a further fine ranging from 25,000 to 1 lakh. And the officer in default might also have to face a jail term of up to 6 months. So this is like compound interest, a penalty on a penalty. I have tried to cover as many penalties as I could. You would know that maybe there might be a lot of penalties I might have missed. Now the basic thrust of the Companies Act of 2013 is on corporate governance, and then I find nothing wrong with that. When you look at what has happened over the last 5 to 10 years in the corporate world in India, you'd have to admit that loopholes that were prevalent have to be plugged. With this act I have 2 reservations, one reservation and one observation. And I would like to conclude with those 2. The observation is that it's too harsh on small company, and it is anti-small business. And the observation is that I hope that this Act of 13 is not implemented in such a way that the jails of our great nations are full, more of with corporate executives rather than criminals. Thank you, ladies and gentlemen.
Used all the PowerPoint slides with all sections, subsections, etc. because there is no way out. Same to same in case of Devajit Sharma sir. He has also, though he has not used PowerPoint, but he has referred to certain documents in his hand where he is referring certain sections. These are 2 issues which you cannot talk on your general knowledge. Which the Parliament has passed, that is the rule. Now how the law is passed. Last time we had a seminar here on relevance of Vedic texts in modern management. So there we invited a person who was a secretariat at the Rajya Sabha secretariat, an IAS officer. Then he narrated that the process of passing of these acts, how a law, whenever it is there, the legal cell, how these things they do it. There is a parliamentary committee, there is a cabinet committee who goes through the drafts, and that's why when Bikash started, He told the history of the Companies Act 2013. Started from 2004. Took around 10 years to get it clear. Because of certain debates, because of so many deliberations, there are issues, there are parties. We are a country which is in the preamble, socialist, sovereign, democratic republic. The socialist word is there. At the same time, we wish that our corporate world should flourish. So there are certain contradictions. There will be a person from left mindset who will be there in the, suppose in the cabinet committee, the cabinet ministers committee is there before it is cleared by the cabinet committee, any act or any bill, I can use the word bill, that's better. So that's why this kind of people are there who will be more inclined to penalties and prosecutions. There are people from capitalist mindset. They think that no, penalties and prosecutions are all hindrances. You cannot go for that. If you create such kind of fear in the mind, people can't work. If people have to work, then there must be some kind of free reign, freedom of thinking. Otherwise, every time if you have that fear in mind, then a blank paper has no error. If you do not do anything, there is no mistake. But if you do certain kind of things, there are mistakes. Now, as Devajit Sharma has explained the term fraud, which is also very important. In auditing, normally we go for this distinction of the two terms, mistakes and fraud. Fraud, if you have carefully listened to that, there is intentionally. The court only says that whether you have committed that particular thing, what is your intention for the deceiving of the people or not. These are certain issues where penalties and prosecutions were there. And the first session was on appointment of auditors. As we have told that these are the people who run the company. The governance term has come from the word govern. If you go to Karnataka, the Vidhan Sabha, we call it Vidhan Sauda in Bangalore, there you will find a line called government's work is God's work. And there comes the word governance. When you talk about the term governance, these 20 people, 30 people in the board, they must take care of the entire stakeholders, not only the shareholders. That should come from your conscience. If your conscience is clear, then only these things will come. There was a debate that corporate governance cannot be brought by act and laws. We did not hear the term, as I told you, when we studied corporate, when we studied our post-graduation. What is corporate governance? We did not know. Then there was some Cadbury committee in UK. Cadbury names, normally it is related to a chocolate. But whenever I heard Cadbury committee, is the first committee that was there, which we heard as an Indian, that of corporate governance. Then in India there was Kumar Mangalam Birla committee, this, that, so many things. Then we heard, okay, there is a term called corporate governance. So what is corporate governance all about? The issue is that, yesterday also, Vijay Kapoor sir was telling about SEC. When we had our SEBI, the people who brought SEBI probably did not do so many things because we had got SEC, Securities Exchange Commission in US, and there was copy and pasting was there, and most of the things were taken from Securities and Exchange Commission. But fortunately or unfortunately, US that time did not have intelligent people like Harshad Mehta, did not have intelligent people like Ketan Parikh, Pawan Sachdeva. These are the names who again taught Indian government to see the loopholes. These people made immense money, not by illegal things. Till now, government cannot confidently tell that Harshad Mehta has done anything illegal. What he did, he went to the Act, he went to the SEBI laws, he was a columnist in Economic Times. Then he found that, oh, these are the ways I can create money. And then he started creating money. The only issue is that when you get money, then you run after money, run after money. If he would have stopped at a certain point of time, he would have been one of the richest person in the world. But he did not stop. He went on to a certain point where it cannot be allowed by the government to do that kind of things. And then we realized every point of time that what is corporate governance all about. Whether it should come from your own heart or not. We have just got a head count here, 101 persons. But we have got a signature of 125 people today in this system. Few people are there here in corporate governance. We are talking about all conscience, logic. I can send it to forensic or make a see that who have given signatures for your friends. Okay? But think about it. When we discuss this kind of things, as he says, no, because that one of you may be in the board of directors tomorrow. Maybe. Who knows? You do not know your future. Now we learn that okay, there should be a dean for becoming a board of director. Minimum Sharma was telling let us apply for a dean first. Otherwise, how can we be a board of director? So let's go for dean. Tomorrow all of you will be there. And as he used the new terms SSD, a small shareholders director. Then the KMP, key management personnel. These are the things. So anyone can become a director, and the director, when we talk about this corporate governance, it is only the conscience. Devajit sir had talked about all these prosecutions, imprisonment, etc. It will come at a much later place. We do not know in the history of Indian companies law how many people are imprisoned because of violation of this. Because still, as he talked about certain appellate tribunal, this, that, there are so many things. Safeguard mechanism is there. Imprisonment is the last one. When you are actually given the sentence of imprisonment, then that is the long process. But in between there are so many things. So that's why even if the penalties and prosecutions are there, but the appointment of directors, the directors should run the company in the best interest. And that is the essence. And that's why the Companies Act 2013 had told so many things about the qualification of board of director. So many things about the, I think 2/3 was also there in 56, no? Rotation. By rotation this was there. So Companies Act somehow wants to see that the company is run by good persons who see the interest of the person. Suppose it is Reliance, it is in Mumbai, a person from Tezpur has invested money there. The board of directors should take care of the investment of that person in Tezpur or in Jamuguri or anywhere inside a village. And that is what today's two discussions are. Now I make open to you to ask certain queries, certain questions on either on appointment of directors or on penalties and prosecution. Both are open to you. Thank you.
A question actually, so just I want your opinion. Since yesterday I was hearing all lectures on corporate governance. I have been out of touch for more than 2 years. Earlier I was teaching commerce in Arunachal Degree College at Itanagar after that Teju. Now I have been posted to another college as principal. I am Kanki Mego, principal Ramphra Government College, Changlang. Now here, when we say corporate governance, before corporate governance there is no prefix. It may be good or bad, but we presume that it is good corporate governance. Good corporate governance on the part of the person who manages the company, affairs of the company. It may be directors, board of directors, or the auditors. Now there are a lot of negatives, penalties. If the board of directors or the managers of the company fails to perform, if they make fraud, or if the auditors fails to caught any fraud, there is negative penalties are there. They are liable to fine. They have, there is provision for imprisonment also. Now suppose a particular company, if they are performing well on the part of corporate social responsibility, there is no award, no motivation. So if the provisions of awards and motivation will be there, certainly I think we do not require such kind of strict rules and regulation. People will directly be motivated for good corporate governance. So what is your opinion? Is there any provision in the Act for awards in the form of tax concession, etc.? And if we include in this particular Act,
this is a valid suggestion. If the person working in a department, maybe a tax department, in the law there is no provision for reward generally. But there are various organizations, even the government, good corporate governance, there are seminars, there are conclaves where company who is doing excellent in good corporate governance, they are being rewarded and recognized. Company who is doing good in CSR activities, they are being rewarded. Company who is presenting their financial statement best way, there are some organizations who are organizing those types of competitions. Best corporate governance, best CSR activities, best financial presentation, award presentation, financial presentation. Even our institute is also awarding the best financial presentation. Last 3-4 years, this in non-profit organization, Akshay Patra is getting that award for the best financial account presentation in non-profit organization. So our institute is doing, company secretary institute is doing, government is also doing. There are some ET, Economic Times and one forum is there, they are rewarding the good corporate governance. Those motivation factors are there. But definitely see, government before this Companies Act 2013 for CSR, government tried, government requested, asked for CSR activities. But unless you know in India our mindset is different. Here unless it has been mandated, companies are not doing CSR. Some companies were doing, but all companies are not. So the government ultimately found it has to be mandated. Now it is compulsory, you have to do it. So they will definitely do it. And they are given some criteria that this way we have to do. Otherwise, if you are doing good corporate governance directly, even if not rewarded, your company's share will boost up. Once your company's share will boost up under your guidance as a managing director or a whole-time director, definitely you can ask for more remuneration from the company. If your company is not giving, some other company will see, yes, Mr. E was the managing director, the company is doing good corporate governance, profit is shooting up, the other company will hire you at a higher rate, your remuneration will be double. So indirectly you will get rewarded. For better work, always directly, indirectly you will get rewarded. But in the act, it is difficult. Government may sometimes put a competition, but corporate governance is such a vast subject, it is very difficult to fix up a criteria on what basis to give a mark and it will be the best corporate governance. So that way, idea was good, but there are certain news where these things are rewarded. It is not that it is not rewarded. Corporate governance is good, CSR activity is good, company is doing excellent, definitely company will be rewarded, their shareholder will be rewarded, and definitely that person will definitely be rewarded. Who is doing good, they are getting huge amount of salaries, other companies are looking for them, they hire them, they are paying them huge salary. So that way they get rewarded.
Whether there can be a provision in the Companies Act, just to have a negative provision as Devajit Sharma Sahab has spent 50 minutes, that too only 30-40% of the total penalties and prosecution is there in the Act itself. Can there be a possibility of positive aspects?
I don't think this can be mandated.
Because the preamble reads regulations. It doesn't provide for incentives. So,
MCA, but MCA itself has their own way.
They highlight that this is the best company, best product. That way it is highlighted, but definitely it is not rewarded.
But in the Act itself in 2013, like penalties, there is no positive section on this for good works.
That's why I told that your idea is good, because if there is so many penalties, negative things are there, there has to be some positive vibes also.
Exactly. Thank you for putting.
MBA. My name is Prashanjit and I'm studying in 4th sem. My question to you is, is it possible that a company has less than 3 directors?
Average company, 3 directors. This is the minimum criteria fixed up.
If it has 2 directors, like you said that 1/3 of the directors should be in the independent.
No, that is in case of public company. Private, it is not applicable for private company.
Rotation is not applicable.
independent.
Okay, is it possible that someone is in relation with the director in the company?
Yes.
Is it possible? It is possible.
There's no problem, because see, when there are small companies, mostly see in our part, in northeastern region, I don't see more than 3-4 listed company other than these PSUs. There are 2-3 listed company max. Earlier there was Guwahati Stock Exchange, some companies were listed in Guwahati Stock Exchange, now Guwahati Stock Exchange has been closed. They don't, hardly there. There are most of the companies are private companies, small company, family company. My family, me, my brother, my sister, or someone is a director, we are running our business. Instead of in a proprietorship firm or a partnership firm, we have formed a company, so that I can deal with a big corporate house. When you deal with a big corporate house or big banks, if you see that here the organization is a corporate organization, so they find it better, they feel it easy to deal with a corporate organization. So generally people, most of the companies here are private companies, some of them are public companies to have more number of shareholders, because there is some restriction on number of shareholders in private companies, that has also been increased this time. So otherwise hardly there are listed companies. So all the companies here you will find in the company, father, mother, son, all these are directors. So there will be, but your question, we have not discussed those, some of the part in detail. There are some difficulties, those we have raised Because there are some provision which says ki suppose one resolution has to be passed, no one should be interested. Now me and my father is a director in a company, in a board, I am going to pass a resolution. Both of we are interested. If there is a resolution for increase of my remuneration, I am interested, being I am the person. My father being my relative, he is also interested. Now how to pass a resolution? There are some difficulties are there, those has been raised because because all the private companies are small companies or a related party. Now how to pass it? Even there are companies, suppose me and my father or my brother is a director, we both are director and we both are the only shareholder. Now I cannot pass the resolution in board meeting because both are interested. Now if you cannot pass a resolution in board meeting, you can go to a higher authority, that is general meeting. Now in general meeting also we both are only the shareholder. So those difficulties will be there, and most of the companies in northeastern region, most of the companies, 99% of the companies you will find related party companies, because all are small companies. Even if the turnover may be big, paid-up capital may be big, but all the shareholders are family shareholders. Out of 10 shareholders, 2 of the family members are the directors. So that way the companies are being run. That's why I told in my beginning of my this, because our attention that the private companies and public companies also not listed companies, both are taken to same board. So it is very difficult sometimes to abide by the law. This is the first year, 2014-15 financial year will be the first year where the entire Companies Act 2013 will have to be followed. So at the time of auditing for 2015 March balance sheet, financial year 2014-15, we have to take into care so many things, and we were discussing while coming from Guwahati that we have to sit again and discuss how to finalize the balance sheet for 15 March. There are so many changes, change in depreciation rates, change in way of how to calculate the depreciation. Now earlier historical cost was there, now the fair market value concept has come. So many things are there. But this is the first year. After that maybe there may be some changes. But most of the companies in northeastern region are small companies. There can be directors, relative director, no problem.
You have insider trading in the company.
Insider trading concept is only for listed companies. Listed company insider trading provisions are very harsh. You become suppose you are a KMP in a company. You are a KMP in a Reliance Industries Limited. Now Reliance Industries came to know today. Today the stock market didn't know that the company has got such a huge reserve of oil. The price is stagnant maybe 1,000 rupees. But as soon as it is announced, the price may go up to 1,500 rupees. Being a KMP, you are having the information, privileged information as a KMP, and you bought the shares in your name or your wife's name or your family name, because you know that after 6 days, once this is announced, share price will go up. Then there will be the question of insider trading will come. Otherwise, in case of private companies and all, hardly there are question of insider trading.
There are 1/3 of directors as independent directors. So do the independent directors have different duties other than the other directors, or do they have any less duty or more duty? What is the difference between the other directors and why is he the independent director?
See, independent director, whole-time director is a director who is in full-time employment of the company. His duty will be definitely be more. Managing director is a person having the substantial power to run the company. His duty will be independent director. Earlier, independent director came through listing agreement, through SEBI. So their duty was not that much. Now it has been given in the act. They are also responsible. They cannot say earlier what happened. Independent director used to come, sit, listen. They hardly discuss things and go. We don't know anything. Now the independent director cannot say if any decision has been taken in the board. And since a director is independent director, he will take the decision into account in general terms. Okay, whether this is good for the company or not, whose interest has been affected, he has nothing to bother because he is not interested there. If anything goes wrong, he is to blow the whistle. That is his main duty. And generally there are some committees that audit committee, because finance is the main backbone of a company, of any commercial organization. In audit company, independent director has to be a chairman of the audit company. That is a compulsion. Those things are there. So those areas, independent director has been given more power and more duties, because where finance is involved. And they are supposed to take part in everything, but they are not supposed to do day-to-day work.
Such variances in penalties, like we have seen, you have mentioned regarding more than one in numbers, like if the penalty is 2,000 rupees or 6 months, whereas in other cases the penalty ranges from 50,000 to 5 lakhs or 6 months to 1 year of imprisonment. Why such variance? Like, why such difference is that? Like, is it justifiable, like 6 months with 2,000 rupees, or how can it be at par with them?
Thankfully, you can't. It's how the powers that be see the offence. It's how heavy they think the offence is. It's not up to me. I cannot give you a justification if you perceive it to be different. But I've just expressed what the law says, and it's about the people after this piece of legislation, how serious they see every offence. Now, the din, an offence of din might not seem very, very serious to you, but in the larger scheme of things, how they propose to control the directors, that's why they made din compulsory and the information about din compulsory. See, it's how they want to control the corporate directors in all the, around the country. That is why they regard it as quite a serious business. So it's how the policymakers perceive.
So if that is serious matter, like issuing more than one win number, then the penalty should be also more. Why only 2,000 rupees then? If that's my question.
I don't have an answer to that because it depends on what powers
The Parliament Cabinet Committee, whatever they think which offence is more serious. If you do something, some murder, your penalty will be under 302 IPC, maybe hanged. If you are doing some robbery, your penalty may be 6 months. So this type of penalty, maybe people are not doing the crime of murdering, but still the penalty is hard. But people are doing all this theft and robbery, all this thing every day. But if you put, someone can say that if we put harsh penalty for the people who are doing robbery or theft, then people will be afraid of these things will not be done. Murder hardly people do. Murder, everyone cannot do the crime of murder. So that
I don't know whether I said it wrong. The range is up to 50,000 the penalty if you violate sections relating to din. And there is also the director concerned might also have to face a prison term. What do you want? More serious penalties?
Then, so my question is, suppose in between a financial year, one or more director dies, and the AGM is not nearby. Sir, what?
See, I told you that there is 2 to 3 criteria, then it is called a casual vacancy. In case of casual vacancy, Board of Directors has been empowered to appoint director in casual vacancy for that purpose.
As you mentioned, 15 is the max. Size of the board. So as you mentioned, 15 is the maximum, or if they want more, they have to pass a resolution. So my question is whether the board size is affecting the the performance of the institution. Is there any relationship between that?
Yes, definitely. You see, there's so many finance business, they've got treasury functions, they've got so many work. So in that case, there might be more people to discharge their duties. Which is small company, 2 person can run. That's why minimum 3 directors has been provided for. Minimum 3 directors to be there. If the company wants, if the shareholder want more director, they can have more director. If they want more responsible people. Say suppose we 3 are in a board of a company. He is from business mission, I am from finance, he is from taxation. We thought we are going into some engineering business. We thought we should have a director who is of engineering background. We want a director from engineering background. We can have a director from engineering background. That depends on the requirement of the company. Definitely it will affect. If you have a more expertise people in your board, suppose there is a discussion on engineering, erecting some engineering instrument or engineering industry. In that case, if we 3 are only in the board and we will discuss what we will discuss. We hardly know anything about the technicalities of engineering or instrumentation. So if the board, a director from engineering background will be there, definitely will add on to the decision. So that way, the board should be a mixture of people from all fields, taxation, finance, treasury, engineering, whatever field the company is into the business. So that way it is beneficial. Otherwise, there is no hard and fast. Only 3 minimum directors. Thereafter, you can go on increasing as much as the requirement of the company.
Sir, yesterday, while talking about the corporate governance, the 2 keywords that came forward was integrity and conscience. But while you are saying about the disqualification of directors, people who have imprisoned for 6 months to I think 2 years, they are also eligible for appointed as director later. Don't you think that contradicts the basic integrity and conscience thing?
I could not get you. Then only he can become a director. And if he is imprisonment for 7 years, then he cannot be a director for life.
Person of a company, can we expect that you will work with integrity or conscience?
Definitely the company don't do things intentionally. Sometimes you don't do things intentionally, but because of some reason he was convicted, 6 months. See, 5 years is a big time. Once you are imprisoned for 6 months, then after 5 years is passed. There are many big criminals who become sent later on. So 5 years time has been given. If you become sent, you can appoint. If you don't think that he is changed, don't appoint him. After 6 months, after completing imprisonment, in the 5 years, he will notice his activities, what he has done. So on the basis of the background, he can be appointed. It is to complete to take the call.
And in any case, prison is supposed to be a reform place. Maybe he gets reformed after 6 months.
So my question is regarding dormant company. The Companies Act 2013 has introduced the concept of a dormant company. So what are the reporting requirements for a dormant company? And also I want to know how many directors is required, minimum number of directors that are required to be elected for a dormant company.
Particular period, this is, I have not gone in detail, but they have to intimate to the registrar that it is, we are not into business and those things. Thereafter, it is required to file the returns.
They are exempted from filing.
They are exempted from filing returns and all. But otherwise, there has to be minimum 2 directors. If there are no 2 directors, then the company become defunct company. The ROC will strike off that company. So minimum 2 directors has to be there. Dormant company means the company which is not in business. See, out of 13.
The exemption is just for filing of returns to the ROC. You've got to be a dormant company, you have to have the same number.
2013.
Register value I have read somewhere. This register value are for solution of fixed assets and all. I think for the purpose of depreciation. IFRS is coming.
Actually, I think this is related to your depreciation
and IFRS.
And IFRS because what is going to happen, they change the method of depreciation. And
this year method of depreciation is to be changed. Earlier it was written down value cost method. Now the concept has gone. You have to find out the value, take salvage value, and the life of the asset.
Sir, I believe that this Companies Act 2013 and whatever we are speaking of is for efficient corporate governance. Now my statement is that high level of corruption become visible only after the revelation of a big financial scam. So my question regarding this is that why a tainted person is allowed to become a director actually in any company? So because when a person is accused of something, there might be a question about something is integrity and others, which has already been spoken about by my friend. So why is it allowed that a tainted person is allowed to be, for example, Mr. P.P. Chakrabarti of IIT Kharagpur, so he was appointed for that one. So that's what I wanted to ask. So why a person is allowed if he's already tainted to become a director or something?
7 years, then you cannot be a director anytime. 6 months, if you have been in prison for 6 months, that means your offense is not that big, not that big offense you have committed. For a small offense, you cannot punish a person for a whole life. Secondly, for a public company or listed company, it is the shareholders will to decide whether to appoint a director or not. If I am the owner, I think I want to appoint him, I have full right to appoint, and a single person cannot do anything. If I have been appointed, you can say that there are other stakeholders, bank has the right to appoint a nominee director. Even if he is a tempted director, you can keep more watch on him. You can become a watchdog as an independent director, as a nominee director. You cannot stop a person for life. Even a person who are committing big fraud, big things, also you have to give time to come. In many big corporate houses, there are family directors, there are tainted people. So if there are one third is independent director, they can have a one, they can blow the whistle.
Say, tainted persons to become director of these companies of any sort.
There are many people who are not convicted, but we personally know he is a tainted person. That way, if you think, then it is very difficult.
So it's just allowing them to be appointed directors. So if the shareholders don't want to appoint a tainted person, they won't appoint a tainted person.
So then why are you taking this commission actually? That's what I want.
The shareholders might want to appoint a person who they feel has been wronged and has served 6 months in prison. In any case, they have to wait 5 more years after that.
Yes. So my question to you is, under what circumstances does a BOD become a rubber stamp? Like it is not able to have a control over the affairs of the CEO.
Might happen that 3 directors, they are doing whatever they want. Then the general meeting, ultimately see today or tomorrow, within 1 year AGM will be there. Even there are in the meetings, if you go in detail the provisions of meeting, shareholder has a right to call for a general meeting. If the simple provision, they can remove a director. They can remove entire board because the highest body is the general body. Now if you say general body want to do something wrong, let them do. They are the owner. 100 shareholders, they want to do something wrong. They are the owner, their money is involved, they are the stockholder. They want to do this, let them do. Because they have to comply with the law. If they do something wrong against the law, then government will catch hold of them. The owner, they want to do something wrong, they can do. Otherwise, CEO has no power to do something wrong. He can, sometimes he has taken wrong decision. Board, some decision, whatever decision he will take, that has to be authorized, that has to be delegated by the board. Whatever board will delegate to a CEO or managing director. That only he can do. It is not that I am a managing director, I can do anything. I can sell the entire factory of the company. He cannot do. Yes.
The auditors face trouble because of the act. Because if they do or if they perform their job with sincerity and ethical value, what is the reason for them to face trouble because of the act?
You see, the problem here is management, things like management representations. This is causing concern because it appears from what's the words of the sections that have been introduced and the penalties that have been framed is way far too high, because you're fixing a penalty that might go up to 5 lakhs where there is no fraud. When I believe no fee in the state, at least in the northeast, usually 5 lakhs. And secondly, this concept of detecting fraud and the procedure that has been prescribed has been diluted down a little now from the original version what it was earlier. That is also causing consternation. Yes, I admit the auditors are supposed to discharge the duties with a lot of integrity, and maybe it's what happened in Sarkar, the government is looking down on us, and maybe it's a knee-jerk reaction which we feel is too heavy. That's the only thing. We don't deny the fact that we should be acting with integrity. We do not deny the fact that if we have made a mistake, we should be penalized. What we do not like is the insinuation after Satyam that all chartered accountants are like that. That is one. And secondly, these penalties are way too high for us. Okay?
It's 10 today. If anything wrong has been done, I might not be able to detect. Directors are the people who are sitting there. There are independent directors, there are authorities, there are income tax department. So many people are there. They are involved on day-to-day basis.
For 182 days. So is that physical presence is necessary, or he can be present by electronic means also?
182 days in India.
Yes,
Yes.
How
he will be present electronically in India?
So means in board meetings or like that?
Not about board meetings. State director means a person who is into the state where the board more than 200 days, then you cannot be. One director has to be a person who is
Resident in the country.
Resident in the country.
Yes.
Brother, also income tax.
Income tax. Whenever I call a NRI, that means he is not resident. So
that means a resident NRI.
182. There are more clauses. You can discuss it.
An individual can be a director for as many 20 companies. So at the same time, so does he draw salary from all these companies?
Yes.
At the same time.
Draw remuneration. See, if you are a director in a company, definitely you are providing some services. If you are director in 20 companies, you cannot provide whole time. You cannot be whole time director in 20 companies. You cannot give services. There are many directors who are just taking part in board meetings. They are not taking part in day-to-day activity. They are coming to the board, discuss, take part in the discussion, give their input for the decision to be taken, and they get the director sitting fees. That is called director sitting fees. And if you are in whole time, they will get. You have to be in employment to get the remuneration as a director. Otherwise, you will get sitting fees only.
This is the second question, huh?
Okay, so the second part of the last question. So as a director, he has been working in the company for so many years. So he to have the idea from that company. So sir, is it okay for him to buy the stock?
No, he cannot buy it inside. BP1, MGT 41 form is there. You have to disclose your interest in the company before the registrar of companies. This came newly for this year only. All whatever your interest in the company, whatever sell, whenever you buy a share, you have to intimate that I bought this share. And in case the company finds you bought this share because you have some privileged information that the company is going to earn more profit. Suppose company financially is closed. You have seen the account, you have seen, okay, company's profit has jumped 5 times. Share price is definitely going to jump. And after that you bought shares from the company and you have not disclosed. Even if you have disclosed and the price has gone up, then you will be penalized definitely.
Presumption went wrong. I sent an SMS to Madam, the chairperson of the last session, that we will start this last session at 11:45. I thought that the lecture ended at 11:10. We do not have any kind of questions, we cannot drag it. But very good. And thanks goes to both the resource persons that they could generate so many queries from the students. Thank you for the nice discussion on a very technical aspects of Nirav Bostu. Even then, they have made it so nice that, and I am happy that some students are referring to some sections.
You are referring to
they
some
could
section
refer some sections.
Ask so many questions. I was also not expecting so many questions, but it's good.
Thank you very much.
Thank you.
Sir, and we just end the session here.